Good afternoon, everyone. We'll go ahead and get started. We'll give folks a moment to trickle in. But I guess we'll start with introductions. So, as customary, let's start with our satellite offices in Rochester.
Brian Trick, Licensed Markets, representing self-insured employers.
Oh, Brian, we can hardly hear you.
Brian Trick from Wegmans Food Markets, representing self-insured employers.
Okay, great. We can hear you now. In White Plains?
Clint Petrozello with Amtrust Financial. We're not White Plains.
Not White Plains.
Oh, it's all right. There's a young lady. There's a young lady in White Plains. Is there anyone else that will be joining you? Do you know?
It looks like there are 2 other doctors coming, but they're not here yet.
Okay. And you are?
I'm Dr. Donna DeRosa. I'm from the New York Chiropractic Council.
Okay. Good to meet you. Thank you.
Thank you.
And in New York City?
Clint Petrozello with Amtrust Financial.
I'm Mindy Roller from the New York City Law Department.
Karen Anderson, State Insurance Fund.
Dr. Robert Colbert, Medical Society of the State of New York.
Okay, great. Thank you. And over here, well, Clarissa, I'm the chair of the New York State Workers' Comp.
And I'm Michelle Connors, the facilitator.
Joe Cannabis, New York State AFL-CIO.
Bill Turley, Injured Workers Bar Association.
I'm Matt Mead, Stockton Barker and Mead.
David Wertheim, General Counsel, Workers' Comp.
Herbeth Woods, Executive Director, Workers' Comp.
And Stephanie Zubali, Director of Risk Management and Regulatory Affairs at Workers' Comp.
Thank you.
Okay, so today we're going to talk about the injured worker experience. And next month we have, and I have invited IME entities to discuss their role in the IME process and answer any questions you may have. We'll talk a little bit more about that at the end of the meeting. So today what we would like to do is recap the injured worker experience data from the IME utilization study and also provide some follow-ups to inquiries raised in earlier meetings. We will also have a discussion regarding the injured worker experience generally and get into any specifics as necessary. If needed, we will take a break at some point during this session. So now I'd like to turn it over to Stephanie, who will discuss the data on injured workers.
Thank you, Michelle. So as you know, the board surveyed 374 injured workers who obtained an IME during August of 2018. This slide summarizes the key findings from the 109 respondents. The majority of respondents stated that the location was convenient and accessible, the medical office was clean, and that the provider and office staff acted in a professional manner. Approximately 2/3 stated that they had to wait 15 minutes or more to be seen by the provider. Half stated that the physical examination was less than 15 minutes long, and approximately half stated that their IME report was not a fair representation of their examination. The next series of slides presents the survey responses from each of the 20 questions asked. Question 1 asked, did you attend an IME in August 2018? Most of the survey respondents, 92%, attended an IME in August 2018. Of the 6 respondents who selected no, 4 actually had a record review. 1 was an IME that took place in late July 2018, not August. Of the 3 respondents who did not choose to answer this question, 1 was actually a record review. So those all come in on an IME-4. So we were not able, when we sent out the injured worker questionnaire, we weren't able to determine whether it was a record review or an actual exam. So that's why some of those folks were included in the injured worker survey.
I beg your pardon.
Sure.
Can you tell us what happened to the other 2 folks?
We can look into it. It appears that they did have an IME, but they just didn't answer question.
And
Did you have
then-
an IME?
And the one who said no, but wasn't included in the, I think you said 6 said no? Is that right?
6 said no,
So
4 of
four
those
had
were
a
record
record.
reviews. One of them was actually
July. And what was the last?
I don't know offhand, but we can get back to you on that.
Okay.
So during the outreach with stakeholders last year, stakeholders raised concerns over the location of the IME and whether or not it was convenient to the injured worker. So question 2 of the survey asked, was the medical office in a convenient and accessible location within a reasonable distance from your residence? 2/3 of the respondents indicated that the medical office was convenient and accessible for them. Stakeholders also raised concerns about the conditions of the office where the IME was performed. Question 3 asked, was the medical office clean? 89% of respondents indicated that the medical office was clean. Concerns were also raised about the length of time. Oh,
I'm
sorry. Yep.
So for the I don't know, 7 or 8 folks who said no, and then however many who didn't respond, was there any follow-up? Like about the conditions in the office?
Any follow-up on our part?
Yes.
No, because as part of the injured worker survey, we specifically told them that there would be no impact on their case, and we also did not follow up in any way on any issues that they brought to our attention, on any of the questions.
May I ask a question on slide 6?
Sure.
The question asks about the location and accessibility from the residents. Was a comparison done to where it is in reference to where they traveled for treatment? Was a comparison made? Perhaps the office that they went for treatment allegedly might be closer or further away. Did we ask that?
We did not ask that, but we could go in and, you know, do a Google map analysis of the distance from where the exam occurred and where their residence is, if that would be helpful.
I think it would be, because if somebody's complaining about it being inconvenient, that the data shows that they are in a position to travel even further for treatment, that might impact the need for more individuals to participate in the process, or it could give us some insight into the quality of that answer.
Okay, so are you looking then just for the individuals that said no? What was the
Yes.
distance?
I would
Yes.
ask that you include all of them. If we're
Would
gonna
you
look at
like
this
to help us?
distance.
No.
Absolutely. I'm willing to help however I can.
Yeah, no, it's 370, or, well, no, it's 109 responses, so we can get through it. Yeah.
Thank you.
Okay, so we were on
7.
slide 7. Okay, so stakeholders raised concerns about the conditions of the office where the IMEs were performed, and 89% indicated that the medical office was clean. Next, concerns were also raised about the lengthy wait times injured workers may face when they arrive for the IME. So we asked question 4, which was approximately how long did you wait at the office before you were seen by the IME provider? Based on the injured workers' recollections, almost 2/3 had wait times exceeding 15 minutes.
Before we leave that one, this one that raises a lot of questions. The question doesn't ask, in comparison to when the scheduled IME time was called for. It doesn't ask if the injured individual showed up on time. Did that wait? If they came early, when did they start the counting? The question should be, how long did you wait from your appointment time would be one way I would have liked to have seen this worded. But it also doesn't say, when did you get there? Because if somebody came an hour and a half late and then had to wait a half an hour or 40 minutes, that sheds a different light on this. On the other hand, if an office has a very high percentage of having claimants wait for it, I think we should know that too.
Yeah, I think that's a fair point. I think this is just, this was really some very basic information we're trying to gather on the process. So I think, if we had it to do over again, we could probably have refined that question a little bit more.
Thank you.
Okay, on slide 9, stakeholder comments also were made regarding the atmosphere of the IME provider's office. So in question 5, we asked, did the office staff and IME provider act in a professional manner? 82% of respondents indicated the office staff and their IME provider acted in a professional manner. Question 6 asked...
I'm sorry.
Yep.
Did the injured workers have an opportunity? I'm not going to keep asking about follow-up. You didn't follow up on anything, right?
We did not follow up with the injured worker on any
Did
of
they
these.
have an opportunity to explain anywhere? Was there like a drop down or some type of area where they could write in what type of unprofessional conduct they encountered?
They could include comments either for individual questions, or there was a catch-all at the end where they could add any additional comments.
And did any add any additional comments about?
For this specific question, I don't know that offhand, but we can get back to you on that.
I would be interested to see the additional comments in total, and I think it's pertinent.
I think we have to be careful. I mean, this was an anonymous survey, and I think that, we'll review them and kind of see if there's
How about
any
redact
insight.
identifying information? Would you be willing to do that?
What we could potentially do is maybe give you some of the comments just separate and apart, like not, like a spreadsheet, let's say. So they're not
I don't
attached to the
care.
questionnaire or anything else.
I don't care to see what they, how they said it, or how they wrote it, or how they filled out the form, but I think that seeing all of the comments would be helpful.
Yeah, I think, again, I want to make sure that we go back, because if it's something that it talks about somebody's specific case, I think we would say that's not something that we feel comfortable releasing. If it's a general comment that you could attribute to any case that's out there.
Yeah, here's my concern is that, I think that redaction might be the way to go, because, they may say something that, the members of the panel here would find instructive in connection with, naming a doctor or naming an employer. So in my mind, redact the name of the employer, redact the identifying information to give us the comments.
Yeah, I think we'll go back to the comments. I think what you're going to find is they're not very specific. But if they are, I think that's the concern we have. So the non-specific, general, high level, totally fine. The ones that get a little bit more, I think we'll just have to kind of go through and see what's.
I'm interested in, I was treated very well, they were very professional, they did a thorough exam, or I went in there and there was blood on the wall, or whatever, but
Yeah,
that's
I don't
the type
think
of
there's-
specificity,
yeah. Okay.
that I think would be helpful, but it seems like you're resistant to sharing the.
Well, I just want to be very mindful.
Any type of specific information.
Yeah, I just want to be very mindful that we promised these people when they filled this out that their information would be kept confidential. And so that's really what we're trying to protect. We told them that there would be no, none of their response would be provided. It was just like internal for the survey purposes. So I just want to make sure, we'll take it back. I understand what you're looking for, and just make sure that we can protect them. Because I think we made a commitment to them, and I want to make sure that, people don't feel like we violated our promise by releasing certain information. So.
Understood.
We did have a question from New York City.
Yeah, hi, it's Mindy. I just wanted to ask, I don't know, my impression is that this survey was designed to get a sense, and not with specificity, of the overall experience of injured workers. So I'm not sure, I think we can all agree that we would like to see the office staff and IME provider act in a professional manner. I don't see what additional data or comments, what insight that's going to give us, or change the group's consensus that that's an important factor. So I just think we have more important fish to fry, and I would be important to move forward a little bit.
I would like to weigh in. I agree with Joe. This is important. If we're talking about professionalism, this might lead to education for the physician community. And if we can do something that would improve the experience and/or quality of care, I'm all for it.
Thank you for your comments.
I do have one follow-up. I think that this is a matter of degree. If someone is gruff and rude and truculent, that's unprofessional, but it really, it might just be subject to another person's perception.
Subjective.
If if an IME goes in there and hurts somebody while trying to test their range of motion by forcing an extremity, that is not only unprofessional, but it's dangerous, and it's potentially hurting the injured worker. So I think that it is pertinent.
Well, I would say it may be pertinent for lots of reasons, but I would have to think, and correct me if I'm wrong, from the board, that if that was the information that was received on one of these surveys, the board would have had an interest in following up.
Well, again, I think we took the comments and we followed up internally with in different areas, as opposed to reaching back out to the injured worker. I think we were very mindful, because as soon as you call them back and say, oh, I noticed on your survey you responded X, Y, and Z, I feel like we violated the promise that their information be, kept confidential, not used, in any relationship to their case. But I think as soon as you start to ask those questions, people start to get very nervous about, I answered, it's supposed to be a blind survey, how are you calling me back on my comments? So I understand the ask, so in that situation, let's just say, for example, a doctor was, indicated to be rough or whatever the case may be. We would potentially have looked at that and said, do we need to talk to the MDO? Do we need to do any other, follow-up, like, is that an investigation? So those are like administrative things that we can do without going back to that person.
Correct. So that's all I'm saying, is that if you saw that somebody was actually injured, somebody said, I was injured at my IME, I would assume that there would be another avenue for you to explore that concern with.
Correct.
All right.
So, I hear the comments and concerns about the survey, just so everyone understands the purpose of it. And so we'll go back to the overall comments that we received and make a determination about what to share.
Well, we're going back, can we, on the distance traveled, or the accessibility and reasonable distance? I mean, they're slightly subjective terms, but is there a way to, without having to do Google mapping or anything, go at least indicate geographic area in the state for the respondents?
Actually, in a later slide, we do have that broken
Okay.
down for you.
I guess I missed it.
Okay, so we are on slide 10, and this is question 6. The injured workers were asked, did you ask for anyone to accompany you to the exam? Friend, family member, etc. About 2/3 of respondents went to the IME exam alone, and less than 1/3 were accompanied by another person. Question 7 asked, was there an office assistant present during your examination? 39% said that an office assistant was present during the IME exam, and 57% indicated that there was not an office assistant present during the exam.
Excuse me?
Yes.
Did they address the issue of interpreters?
We did not specifically ask about interpreters.
Stephanie?
Yes.
I just wanted to ask, my understanding, and and maybe Dr. Goldberg will correct me, if there was no office assistant, I believe many doctors just leave the door ajar.
Doing an exam.
Not.
What you're saying, Mindy, is correct. And also, many of these exams are limited. It might be an upper extremity, it might be a hand, it might be an elbow, it might be a foot.
Right.
When we think in terms of an office assistant, that's doing a complete general examination with genitalia perhaps being exposed. And we'll see later that it's about 45% females. So if we take a look at that, and of those females, if it's upper extremity, hand, wrist, elbow, knee, you don't have to get undressed and need to understand, particularly with an open door.
Yeah, it's Rick Weinstein from Orthopedics. I agree 100%. And for lumbar spine injuries, you don't need an assistant in the office. The assistant is really for urologic examination for genitalia deformities or injuries.
Okay, thanks.
Good to know, thank you.
Okay, question 8 asked, was the IME provider present for the entire examination, i.e. no portion of it was conducted by an assistant? 83% of respondents indicated that the IME provider was present for the entire examination, and 11% said that the IME provider was not present during the entire exam.
another question is, do we know what they were not present for? In other words, if I go to my own treating physician and he doesn't take my, or she doesn't take my blood pressure, for example, so we know what they were not present for?
We do not know that from this survey. What we were really driving at was, did the provider perform the exam, or maybe did they have an assistant do part of the evaluation? So it was a general question about whether the IME provider was there for the full time. Question 9 asked, did you complete a questionnaire documenting your injury or medical history? 79% of respondents completed a questionnaire about their injury and medical history, 15% did not.
This is an interesting question, because very often individuals who present for the exams are instructed by their representative not to put anything in writing and not to answer questionnaire. Did you ask that, or you told not to either not answer or answer?
No.
What they were told.
Yeah, so the 20 questions that are in here are exactly the same questions that we asked the injured workers. So we did not ask about attorney representation, although later on we do have a slide that has some information about attorney representation.
My question goes beyond representation. I appreciate you saying that. This goes to what an individual might have been told in advance of presenting for an IME.
Yeah, I think we understand the question. I think I don't think we felt that that was an appropriate question for us to be asking in this survey.
Okay.
Question 10 asked, during the IME, did the IME provider ask you about your medical history and current condition or current concerns? A majority, 73%, indicated that the IME provider asked about the medical history and current concerns, and 21% of respondents said they were not asked these questions by the IME provider.
Hey, it's Rick Weinstein again. We don't care about their medical history when we do the IMEs. It's only the relevant history that needs to be obtained. So if someone's coming for a wrist injury, we don't care about their cardiac history. So I don't know if this question has any relevance.
I think it has a lot of relevance.
It doesn't for this particular.
For claimants, it does. Because this particular issue here is very often used against claimants on Section 114 issues.
But if someone's coming in for a wrist fracture, their cardiac history, lung history, diabetes history is not relevant. So this is an independent medical exam. We're not the treating physicians. We have to remember that. So it's not relevant.
Excuse me, I just also want to add, when you say medical history, and this sort of, I agree, you don't know, is that your medical history in terms of a variety of things or specific to this injury?
Right. There could be relevant things. If someone falls down and they hit their chest and they have chest pain, you got to get a cardiac history. But if someone falls down, fractured their distal radius, it's not relevant to say, well, yeah, you had a lung problem 12 years ago. So I think a relevant medical history makes sense.
Okay.
Also, there doesn't seem to be any indication of what the overlap is between asking about medical history and the questionnaire that they are or are not filling out, which may well include a medical history.
Right.
Well, if it's not relevant, we have someone who conducts IMEs saying that it's not relevant to ask about medical history, and almost 74% are asking about medical history. I think that that's instructive here. Is this a fishing expedition looking to jam somebody up on a totally unrelated fraud accusation because they didn't divulge something about their cardiac history in relation to that wrist injury?
I think the issue might be in the way the question is phrased. If the question was phrased, did the IME provider ask you about your entire medical history? Or if the question was phrased, did the IME provider ask you about your medical history related to your occupational injury? You would have gotten different results because that's a level of precision that's missing in the question.
And I think you're right, and that can explain why 75% did, which goes to Joe, your concern. I think that this can represent either of those two scenarios, and it would be difficult for an individual to answer it not considering the other.
Okay, thank you. On question 11, injured workers were asked, did the IME provider examine or perform tests on your injured body parts? Almost 80% of respondents indicated that the IME provider examined or performed tests on the injured body parts, whereas 15% stated that their injured body part was not examined or tested.
Were any of those 15% record reviews?
We can go back and, I would think so, but we can go back and verify.
Because clearly they would not have examined it.
Right.
And of those 15%, did any of the claimants say that they had fully recovered from their injuries before the IME?
I think, as Stephanie mentioned, this is the exact question that was put to them. I mean, and just to back up a little bit for perspective, this questionnaire was really sent, when we did all of the stakeholder outreach, there were a lot of comments or concerns about, what's really happening at the exam itself. So we just really were trying to get basic information about, what are people's perception of this process and how it's, is it convenient? Are they professional? Things like that. So, could we have asked a 50-question survey? Absolutely. But I think we were just trying to gauge the industry and not really base this whole IME advisory committee on, the response of 100 people who got an exam. So, again, we could have drilled in deeper, but this is really how it was asked, and so there was no follow-up questions if they said yes or no.
So, Mary Beth, I just want to say, I think that that's very clear. It makes sense to me that you are getting essentially a broad picture without a tremendous amount of specificity, but I think that the point is that we just want to, I think everybody wants to be clear that these are not necessarily the most specific or the most, you're not getting the most precise picture from that, and that's okay. I think that's fine. But it just also to rely upon it in a very specific way would be, sort of, I don't know whether it would be naive or foolish, because again, what you just said, it's just it's a broad picture of what's going on there.
Right, I'm not by any means saying we should just rely on the saying it's fine out there. I'm just saying that, we heard that the conditions were terrible, the people doing them were not professional, so we were just trying to address those concerns that were raised during that stakeholder outreach that we did. The fact that there are additional questions about, what's examined, how it's examined, should we take a further detailed medical history or not, those are questions that are perfectly fine to be addressed here, and we can talk those through, but that wasn't like the focus of this survey, is my point.
Okay, so moving along, question 12 asked, did the IME provider perform tests on the opposite non-injured body part? Slightly more than half, 52% of respondents were tested on the opposite non-injured body part, and 40% indicated that they were not. Question 13 asked, did the IME provider use any testing instruments to examine your injured body parts? More than half, 55% of respondents indicated that the IME providers used testing instruments to examine the injured body parts, and just over a third were not tested with instruments. Question 14.
I have a question, I'm sorry.
Sure.
For the doctors or anyone else who could provide some information on this, aside from assessing range of motion, is it common to use instruments to test the other types of injuries?
Yes, we might use tape measures to see the presence or absence of atrophy. We will use reflex hammers to test the integrity of the peripheral nervous system. We may use light touch vibration sense to see if there are sensory impairments. So there are a number of other instruments that we will use, including a stethoscope, depending on what that individual may have. We may use a dynamometer to determine grasp strength or pinch strength. So there are a handful, Joe, that we might use during an exam.
Yeah, as an orthopedist, the only thing I will really use is a goniometer, and other than that, manual testing.
Thank you.
Question 14, did the IME provider use any testing instruments on the opposite non-injured body part? Slightly more than half, 51% of respondents indicated that they were not tested with instruments on the opposite non-injured body part.
In regard to that,
Yep.
I think those cases are obviously going to involve extremities. They're not going to involve spinal injuries. So
Yes.
could that account for a lot of the response? They
Uh,
responded no.
Yeah, that could. Several stakeholders raised comments regarding the brevity of time spent with the IME provider. So in question 15, we asked approximately how long did the examination take? Injured workers they were given 3 options: less than 15 minutes, 16 to 30 minutes, or over 30 minutes. Almost half, 47% of the injured workers indicated that the IME was less than 15 minutes. Question 16 asked,
Do we have a question?
No, I just wanted to, it was interesting for me that about half also said that they spent between 16 and over 30 minutes on their IME, so they were about equal.
right,
Hey, it's Rick Weinstein again. I just want to make a comment. These exams for most doctors should take less than 15 minutes. And I don't know why there's a feeling that if it's less than 15 minutes, it's not a good exam, because most of the exams can even be done in less than 10 minutes. So it depends what's affected. If it's multiple body parts, neck, back, shoulder, knee, hip, then it can take longer. But if it's just 1 or 2 body parts, it should not take more than 10 minutes. And that's to examine both sides.
thank you. So question 16 asked, did you receive a copy of the IME-4 report? Most respondents, 83%, received a copy of the IME-4 report. 11% indicated that they did not receive a copy of the IME report, although it is mandatory that the injured worker and other parties of interest receive a copy of the IME-4 report on the same day and same manner. Several stakeholders raised concerns over the fairness of the IME report and whether the opinion was objective. So question 17 asked, do you believe that the IME-4 report submitted by the IME provider is a fair representation of your examination? 46% of respondents indicated that they believe the IME-4 report was not a fair representation of their examination, and close to 12% chose not to answer this question.
Do we have any idea, based on comments, what that assessment is based on? I mean, on the one hand, you have a claimant who is a layperson. On the other hand, you have a physician or a medical professional making a medical determination. I have a hard time understanding how a layperson can even make this determination, whether what they're reading is a fair assessment. So were there any comments to indicate what was or not perceived as fair?
Well, I'm sure that there are some, well, I don't know that there are questions that specifically address whether it was fair or not, but what we did, and it's included as handout number 4, is we took a look at the individuals who responded, the 46% who responded and said it was not a fair exam, or it was not a fair representation of the exam. And compared that to the others, and identified, certain questions where there was a statistical variance in between those who felt the exam was not fair and those who felt it was fair or did not respond. So again, that's in handout number 4. There are several, if you want to move to handout number 4, there are several where there was a significant variance. For example, number 5, did the office staff and IME provider act in a professional manner? 75% of the respondents who said it was not a fair representation said that they acted professionally, whereas 95% of the others. So I guess you could infer that the folks did not feel that the office staff acted in a professional manner. So there was question 5 where there was a significant variation. Question 10,
Question
which...
2.
Oh, yes, sorry. Question 2, was it convenient and accessible location? Question 10, which asked, did the IME provider ask about your medical history and current concerns? Question 11, did they examine body parts? Did they use testing instruments?
I mean, I recognize from this that this group of people were, I guess, more dissatisfied with the experience than the others. But I guess I question whether it is a fair question to begin with, whether a layperson can determine whether an IME4 is a fair representation. It's a difficult thing to measure.
We tried to ask, was it a fair representation of your experience, your exam, not do you agree with the results? It was not meant to gauge that. I don't know how they, when they answered yes or no, how they were actually responding. But our goal was to ask if what the doctor wrote up in the IME4 report is consistent with what their recollection of what occurred at the exam.
I think what I'm saying is that if I go into a phlebotomist to get blood drawn, which I hate, and I have an excellent or poor result of the blood test that followed, and I get that sent to me, it is not at all an accurate representation, for better or for worse, of my overall experience, which is horrible, by the way. They're just not related.
Yeah.
And I think that that's the case here. I'm not certain there's any relationship whatsoever, or if this is a relevant measure of anything, for what it's worth.
I don't think that's a fair comparison.
I like your statement that it was looking at your experience of the examination. That's not what this reads.
That's right.
And I don't know if the individual would understand how to answer the question.
That's what I'm saying.
So when we do the exams, I don't know what % were record reviews, which would affect the no. And I also don't know what the perception of the injured claimant is with respect to pain, and how the schedule loss of use guidelines discuss and consider or discount pain. So depending on how someone feels and what objective criteria there are, there can be a disconnect.
I think that it's an unfair. I think that it's an unfair comparison. There is as much as we would like to apply objective standards to these examinations, there is much more subjectivity on the part of the provider here than a blood test. It's just they're apples and oranges, and I don't think that it's fair. And I think that we're running the risk here of almost holding injured workers in contempt. Like they can't possibly understand what's fair or not. I think it's.
But that's not what I'm saying. And the analogy is not meant to be analogous, that they're identical situations. But I think that there's no question that what a doctor puts on an IME report may be far too technical for me to understand, may be far too technical for an injured worker to understand. So I couldn't possibly judge whether or not that was a fair representation. It's an impossibility. It has nothing to do with respect or disrespect, and it has nothing to do with the subjectivity that you might think is being applied by a doctor. It's simply, the question doesn't make sense.
So you know more about IME4 reports than I do.
No, I don't.
Is there a place on the report for a doctor to write down what arm or what extremity they examined?
There is now.
Okay. So if an injured worker reads the report and says that the left arm was examined when they know that the right arm was actually examined, there's a basis here for folks to be able to understand this concept.
I will grant you
Are
that if
they,
the wrong arm is
are they
examined,
physicians?
yes.
No, they're probably not physicians. However, I think to say that it's totally unfair or that the results are meaningless is not accurate either. Are there technicalities that you or I or anybody else who's not a physician wouldn't pick up on? I'm sure there are. But to say that the entire question is baseless or unfounded isn't fair.
And I'll agree with you on one point, Joe, and that is that if the IME4 says that the doctor examined all of whatever parts and they didn't do any of those things, anyone can make that determination, right? I mean, that's not just unfair, it's just outright wrong. But everything beyond that, very, very basic, I think is outside of the realm of one being able to describe whether it's a fair representation.
So back to your phlebotomist, right?
Yeah.
You go, you get blood taken, you hate the experience, you get the report back and it's a urinalysis report. You know that it's not a fair representation.
Correct. So,
I mean, to suggest that there's no value in the question, I think is misguided.
I hear what you're saying, but I highly doubt that 45.9% of those that were that answered this response were getting completely wrong sides of their body check, wrong body parts. We're dealing with, I mean, that's just an error that happens once in a blue moon. So I don't think it's
If I
representative
may,
of that.
I think that if we had to do over again, we'd probably be more specific,
Yeah.
just to find out what it is that they're actually taking objection to, right? Are you objecting to the conclusion or the results, or is this not a fair representation of what actually occurred during the exam? And, you know, we didn't do that in this question, and I think that's why there's the issue that, you know, that we're discussing. I think, you know, if we had to do over again, we'd probably be a little bit more specific with a lot of these questions.
So Bill has been trying to get a word in edgewise here.
I have, in 34 years, I've seen a lot of IMEs, and I've gotten a lot of them back from clients with the red pen, and sometimes there's green and blue mixed in there too. And rarely do they contest the diagnosis or any of the medical terminology. Usually it's specifics about themselves. They got my height and weight wrong. I'm a male, I'm not a female. You know, things like that. But also, you will see things like, he never touched this body part. He never examined me, he didn't do this. The exam was 5 minutes long. That's the kind of thing you get back. They really don't get into the actual medical diagnosis. What they do contest often is, well, how can he say that I can lift more than 20 pounds? How can he say that I can sit or stand for more than 20 minutes? That's the kind of thing that we get back. And I'm really not surprised at this, at the results of this question. So.
Do they wonder the same things about when they're treating physicians, tell them they can't lift more than 20 pounds? I mean, that's a serious question, because that physician wouldn't have any more of a way to make that analysis than an IME, right?
Well, they're usually questioned about that in cross-examination.
And it's a very serious
Very,
question.
you know.
I mean, if we're going to base the determination of whether it's a fair experience and stuff like that, then I would have to ask, can a physician treating that person
Well, the question here
make
is
those
about
determinations?
inaccuracies in the report.
Right, no, I understand.
And
I'm
that's
just-
what we get back. But, and normally it is about specifics of the examination. And again, yes, restrictions can be a subjective thing, but.
I think the other thing that we're missing here is that one of these people has an obligation to the injured worker, right? The treating physician is not a diagnostic physician, right? They have an obligation to treat that person.
That wasn't the question I asked, though, Joe.
The IME, right, has no obligation to the injured worker. So if the treating physician says, you're pretty banged up, don't lift anything over 20 pounds, that's a big difference from an IME saying, this person can't lift anything over X without having a conversation with them, without
Joe,
asking them about it.
Joe, a treating physician does have a diagnostic obligation. That's the starting point for any and all treatment, so I take exception to that.
I'm sorry, please excuse my imprecision, but they have a greater obligation to the injured worker. The IME has no obligation to the injured worker. The IME isn't obligated to tell somebody that they know has a life-threatening disease, right, that they've diagnosed and identified, right? There's no obligation there.
none of that changes their ability to make a determination on whether someone should or shouldn't or can't lift any more than a treating physician. I mean, you're correct. Of course, they're the treating physician, and they've maybe spent more time with them, but let's not pretend that an IME doctor suddenly doesn't have the same ability to make those kinds of determinations. That's all I'm saying. These are people with identical educations and experience. It's not good for the goose and then not for the gander. It's identical in that respect.
No, I mean, the treating physician has a lot more experience with the claimant, and we get this all the time.
With the claimant, but you specifically said that how can a doctor make a determination on whether or not I can lift 20 pounds or not?
I didn't say
And-
that.
Yes, you did. You did. And I'm simply asking, how does the treating physician make that determination? They both can. So those kinds of things. All I'm talking about is the relevance of the question. And I don't want to go forward saying that 45% of IMEs are essentially unfair, because I think that it's a completely, it's just frankly not true, and this is not representative of reality. think
I
it's-
agree. I think
Perfect.
that it's probably higher.
I knew you were going there.
We've already heard
Yes.
from doctors who perform IMEs on this panel that generally IMEs think that they have an obligation to deny claims, to decrease
Wait,
awards.
I don't remember hearing that.
Who
I
said
never
that?
heard that.
No one has said that.
No one has said,
Joe heard it.
no one has said that generally their perception is that some of these folks believe that they have an obligation or that their job or that their purpose. Anyone want to pipe up? Or maybe clarify their
That's not what
earlier
you said.
comment?
You said that we have an obligation to find nothing wrong. I don't even believe I'm paraphrasing. That is not
I did-
factual.
So
And
what I said
that is
was,
what you
there
said.
was someone on this panel who said that their perception, okay, is that this is what these folks are expected to do.
You
No, I-
you said a
No,
physician
no,
on this
There's
panel.
some
A
doctors-
physician on this
Yeah.
panel said
Yeah,
that?
let me talk as an orthopedist.
Could one
There are
person
some,
speak at a time?
yeah, there are some doctors who we all know who do take it as their job to deny treatment. But I think that is a very small percentage of the IME doctors. I think most doctors try and be fair about what they're saying and doing. But there are definitely some hired hitmen for each side who will bias their exam and their reports based on who's hiring them.
Excuse me, I just want to address one point that you said there. In terms of treatment, and I think that our last conversation a month ago got derailed because of this. I think treatment is such a small part of this, in the sense that you have the treatment guidelines for most body parts, and forgetting about who's hired to do what. I think that that's a good way to sort of derail this conversation. And I don't think that anybody has said, and I really wonder what you're referring to, Joe, that the IME doctors expect to deny treatment or, in some way say somebody who's disabled is not disabled.
I'll queue up the recording for the next meeting, and I'll have it available for you.
Okay. In the meantime, let's get back to this question. And I think what we can all agree on is that it lacks some specificity, and that's where the tension is coming from about what this no actually means. Yeah,
Oh, I'm
yes?
sorry, I didn't know, I thought you were finished.
No, well, I'm only gonna say that to the extent that we could maybe look at the comments and see if there are any comments that might speak to why they responded that way, we'll do that, we'll summarize them, and we'll see if we can get back to you with more clarity on that. Is everyone okay with that?
Yeah, I just wanted to, say one thing, which is essentially, these questions were also asked after the fact, after the IME. So I have to believe that somebody who received an IME report that was not, and for lack of a better word, favorable to them, didn't give them the degree of disability they expected or the schedules of use that they believed they were entitled to. All of this colors their experience in the past. So I just think that this, as Mary Beth has pointed out, this is sort of a broad strokes kind of a survey, and as you just said yourself, Clarissa, and so that's what we should take away from it. I don't think that we can rely upon it to say this is for sure the truth. But if 80% have one experience and, 10 have another, then I think we get a broad picture of what's going on. That's all.
Right. Yeah, I would agree with that.
All right, so moving along to question 18. Injured workers were asked, did you videotape or record the IME? Almost all respondents, 91%, said they did not video or tape or record the IME, although an injured worker has the right to do so. 3% of respondents did record the IME. Question 19 asked, did the IME provider videotape or record the IME? Most of the IME providers, 79%, did not videotape or record the IME. Approximately 6% of respondents indicated that the IME provider did record it. And the final question, number 20, is, were you advised in advance of the IME physician's intention to videotape or record? And almost all respondents, 92%, did not actually answer this question.
Because they didn't.
Maybe because they didn't, it wasn't relevant, because it wasn't videotaped, but we asked the question nonetheless. So we've provided you with 4 variations on the injured worker survey responses in the 4 handouts. The first handout shows all the responses from injured workers. This handout presents both the survey responses and the counts of the no responses. As requested in handout 2, the injured workers who participated in the survey were matched against IME providers that were identified as high-volume IME providers earlier this year when we talked about the IME provider access topic. The survey responses were then analyzed based on whether they were in the high-volume group or all other provider groups. Also, as requested in handout 3, we have an opioid and non-opioid grouping. The injured worker was deemed to be in the opioid group if there was mention in the claimant's IME report that opioids or controlled substances were involved in the treatment, or opioids and controlled substances were approved by the treating physician or IME provider. The survey responses were then analyzed based on whether they were in the opioid group or a non-opioid group. And as we discussed a few minutes ago, handout 4 represents an analysis of the survey respondents, the 46%, who indicated that they did not believe that the IME report was a fair representation of the exam. Again, the handout shows individual survey question responses for the group of respondents as compared to those who said that their IME was a fair representation. Okay. So the next series of slides provide demographic information regarding the 374 injured workers who were asked to complete an injured worker survey, including a breakout of those who responded and those who did not. The random sample was sent to 212 males and 162 females, resulting in a 57 to 43% split. The responses were very similar at 58% to 42% respectively for males and females. The survey was sent to 334 injured workers in English, and 40 injured workers received the survey in a different language. Slightly more English-speaking injured workers responded to the survey. They represented 89% of the sample, but close to 93% of responders. This next slide shows the distribution of the sample population as well as their responses by New York State district. a proportionately higher percentage of injured workers responded in the Albany and Buffalo districts, and lower response rates occurred in Long Island and Brooklyn. 92% of the survey population was represented by an attorney, and a slightly lower percentage, 90%, of those represented by an attorney responded to the survey. In pulling together this slide, we were not able to verify whether the injured worker had an attorney at the time of the IME or whether representation occurred later. For the sample population, the average number of years from the injury date to the date of the IME was 2.9. For the injured workers who responded, the average number of years from the injury to the IME was slightly higher at 3.3 years. This next slide shows for the sample population, the average number of claims per injured worker was about 3, and this number was similar for the injured workers who responded. 39% of respondents, for 39% of respondents, the claim associated with the August IME was the only claim that they had ever had. This next slide shows the number of prior IMEs. The average number of IMEs that injured workers had experienced prior to the August 2018 IME was 3.8 for both the survey population and those who responded. For 23, which is respondents, which is 21% of the population, this was their first IME. So I can answer any additional questions you may have on the data, or otherwise turn it over to Michelle to start the discussion on injured worker experience.
I just wanted to go back to my first question about the geography of those that were reasonably or felt that the IME was unreasonably far away. And I was wondering, because I see the breakdown geographically of the respondents, but what I'm looking for is of those, of that 30, what was it, like 33% or whatever, that found that it was too far. I'm interested in where they were located geographically.
Okay.
Because, you know, some of it might have a lot to do with simply the geography of the, you know, the area. I think that that's an important piece.
Okay.
Do you have demographic information about race, ethnicity, or national origin?
I don't think that we capture that in our system. No, language is pretty much all that we have.
I just had one question. Are these all cases orthopedic cases, or they're a mix of, let's say, medical illnesses like asthma cases also?
It could be any illness. So the population that we started from was the approximately 14,000 IME4 reports that we received in the fall of 2018 that indicated that the medical service date was in August of 2018. So we took the 14,000 and then did a random sample, which came out to 374, and sent the surveys out to them. And again, that's why there's a couple, 6 that we know of, record reviews that got pulled into the population as well.
I see. Thank you.
Mm-hmm. Are there any other questions?
So at this point, we can start summarizing and talking about the injured worker experience to see what, if any, I know all of you should be able to see the parking lot. We're going to go back on a couple of issues, but to the extent this group would like to make recommendations that are going to improve injured worker experience, you know, do we want to talk about location, professionalism, wait times, et cetera? I think, Lev, I think your point is valid on the geography, and I think they're talking about that in terms of location. So maybe some of these issues potentially get wrapped up into that. Again, you guys are the experts. What do people think on the overall results?
Looking at your parking lot, we talked about the appointment time, and it says, how early did you arrive? It should be, what time did you arrive? Because people can come late, and if they come late and they do experience a wait, it may be perfectly understandable. That doesn't quite capture it. Thank you.
Okay.
But talking about the exam time, there was a comment earlier about 15 minutes should be sufficient. Is that reasonable, not reasonable? Should we even be, making any determinations about what's the appropriate time? Is it all just going to be individual? So if you think about the exam itself, do we need any parameters around it?
I think this goes to that one slide about how many claims that individual has filed. If somebody has as many as 10, 15 minutes is absolutely unreasonable, but that's what the orthopedic surgeon said. If one is looking at a single accident with a single or perhaps two body parts, it's one thing. So I believe the parking lot should drill down much further on that question. But I believe, personally, I think 15 minutes is short.
Excuse me, we didn't ask how long does your own physician take to examine you? I mean, and I think that's a relevant question. I know for myself, generally a doctor does not spend, 15 minutes, sometimes a little bit longer chatting, whatever, but I don't think that that's an unreasonably short exam. And I think similarly, even wait time in the office, how many of us have waited a half an hour in our own doctor's offices, an hour in our doctor's offices? I'm not sure that these are, and most of these, the statistics seem to show that the majority of people were frankly, satisfied with the level of professionalism. I don't think that any of these cry out for like something that's a terrible, terrible experience. I think going to the doctor generally involves waiting a long time, seeing the doctor for a short time. I don't think anything here is different than what we ordinarily experience ourselves.
So I think that it's beyond the scope of the committee. And the other thing is that they're apples and oranges. You're going to one place for treatment, a doctor that you sought out because you think that she or he can provide the best treatment for you. IMEs are an individual subjecting themselves to an evidentiary examination in order to provide their adversary in a legal proceeding with information about their injury. They're two totally different experiences.
But
I agree with you, but I would like to say a few things with regard to that, Joe. Firstly, the fact that you're going to your own doctor, you say that somebody you've sought out for the best treatment possible. I'm not so sure that that's entirely the case generally, and it's not outside the scope, because as you point out, this is evidentiary, and if there was good doctors with fair reports coming in, you wouldn't need this evidence. So I think that to look at one part of the system without looking at it more globally is really a very narrow perspective on this.
And we've gotten a very narrow directive.
I
think Bill is trying to make a point.
Bill, you're far too polite. Just start talking.
It's in my nature. I disagree with that analysis. Has anybody here ever been to an IME before?
I haven't.
I have.
I have not.
And not for me personally, but way back when I first started practicing, I was asked to accompany a client to an IME. And it's pretty intimidating. It really is. And you have to think about the whole concept behind the IME. It's like, you're going here because we don't believe you.
No,
Is that what it is?
No, is that necessarily?
I don't know.
I don't
That's
think
that's
so.
in the claimant's
You
mind
just said
anyway.
that's exactly the reason for IMEs, because the treating docs do such a crummy job, and they're not believable. I mean, that's literally the point that you were just making, was that if there were better treating docs, we wouldn't need IMEs, I believe was exactly what you said. Is that
But
right?
if I could just finish my thought here. We prep a lot of people for IMEs. What's going to happen? What are they going to do? Are my payments going to get cut down? The reality is, yeah, they probably are. And, we just tell them, bring your notice with you, bring ID. You're probably going to sit there for a while. You're going to probably spend more time in the waiting room than you are in the doctor's office. This doctor's not here to help you. He's not here to treat you. He's very different from your own doctor. But anecdotally, we were talking about waiting time. I just had a client tell me that she waited 6 hours to be seen.
Don't you think that's an outlier?
Can I finish, please? She showed up at 3 o'clock. The office was very crowded. She was told to wait out in her car and keep her cell phone on. And she eventually got seen at 9 o'clock.
That's ridiculous.
It's anecdotal, but I believe this actually happened. I remember years ago we had a claimant who was a big burly construction worker who now this is an anomaly. I think the doctor was having some kind of psychological problem himself, but he asked the claimant to disrobe completely to do an ankle examination. And he came and spoke to me about it later, and I said, we can file a complaint, we can do this, we can do that. And he says, no, I'm just too embarrassed to do that. And I said, well, why did you do it in the first place? Because, well, he's a doctor. He told me to do this. I've heard a lot of horror stories over the years, but, I'm not surprised at a lot of what comes out in this survey.
I just wanted to hop back to what Mary Beth was saying a little bit ago. And we were talking about waiting times and what they would be appropriate waiting times, and we were talking about exam times and what would be appropriate times. And I was actually responding to Joe. You have said on a number of occasions, although I completely disagree with you, that IME should only be performed by doctors who are also treating physicians. And you think, and you've said it, if I'm misquoting you in any way, please correct me, but you said that you think that the bulk of people's practice should essentially be practicing medicine and then doing IMEs on the side. So, for us to begin to pretend that it's a different experience in the world that you'd like to set up, we'd be going into doctors' offices where we all experience hour-long waits, where we all experience, the same problems that all of us experience in treating physicians all over. So I think to take that back and then say, so in the IME experience somehow, you should be streamlined in the door, is a little bit silly. Especially in a world, if we're looking to use IME doctors, we're also treating other patients. Are you looking for, or are we looking for some kind of special timeline for IMEs where an IME claimant would walk in the office and be treated immediately over patients getting treatment? I'm just trying to understand what our goal is here when we're talking about these time periods, like the wait times and the exam times. I don't understand where we're going with this, I guess is what I'm saying.
Well, I'm sorry, just to answer your question is, do we want to make any recommendations about what we think the parameters should be around these things? So if we think that there's an issue with wait times or with the duration of the exam, do we want to recommend a range? That's why we're posing it, because we've heard,
I think we could get consensus that it shouldn't be 6 hours. I think that goes without saying. But I think it's very dangerous if we start to set an hour, because we've all waited an hour for things in medical procedures. One way or the other, we've all been there, and it happens even with the best of intentions. And if we start to set hard and fast rules that you guys can fight about, and litigate over, we're opening ourselves up to a worse system, not a better one. Granted, 5 minutes less in a waiting room is advantageous to a claimant, no question about it, but there are a lot of unintended consequences, I think, that would come along with that, so.
So you got some of it right. I do think that removing the financial incentive here would remove some of the bias in the system. As far as, applying my comments about the difference of experience narrowly just to wait times, that's not fair.
No, I was just saying, in that world.
It is a totally different
I said
experience,
it would be one of the outcomes.
and it's not just wait times.
Understood, but we were talking about wait times, Joe.
It's an adversarial experience.
Right.
Right. The injured worker knows.
I hear what you're
the
saying.
injured worker, and
that
there
wasn't
are
my
professionals who don't make it that way and who go out of their way, and I'm talking about in generalities here. This is an adversarial experience. The injured worker is not believed, their doctor is not believed, so the carrier or the employer requests what is an evidentiary examination.
I was making a point simply about waiting times and exam times. I understand what you're saying, but it's irrelevant to what I was
take
saying.
my broad statement about the difference of experience and apply it to one specific.
But we're talking about that specific
I
area
understand.
right
I
now, so I'm
understand.
applying it
It's
thusly.
taking it out of context.
I don't think it was at all, actually.
I would like to weigh in.
Yes,
Not
please.
all independent medical examinations are for the defense, if you want to use that term. Many doctors are called on to do an independent medical exam in lieu of the treating physician, and yes, for evidentiary purposes. And I don't believe we can cast it with a brush to say these are all for the same purpose. They're certainly not. And my experience in the last month tells me that it's not. That it's certainly not true.
So are you talking about tort cases or workers' comp or both?
Injured individuals, independent as to what they were, Joe.
So do you find that you have more IMEs in tort cases than you do in workers' comp cases on behalf of the injured worker?
I don't know.
Or in lieu of the treating physician?
I want to say fewer are in lieu of the treating physician, but they exist.
Okay.
Excuse me,
Can we
Joe?
get information from the board on how many injured workers have IMEs performed on their behalf in lieu of their treating physician providing medical evidence?
I don't know the answer to that question, I'll have to look into it.
But I just want to make sure that I'm clear on what I'm asking for you.
You're asking if the injured worker used a physician other than their own physician to perform the
Yeah, how prevalent it
exam.
is.
I
Thank you.
think we can look into it.
Mindy?
Joe said something I think very important, which is that this is all premised on an adversarial relationship. And I think that that's true to a large extent. So my question to Joe and to the committee at large is, how do we take that out of this entire process? Is there a way to reduce the adversarial nature of this relationship so that everybody is on the same page in an effort to have the claimant treated properly and return to work and help as to the best of their ability? Is there, it seems to me, rather than get bogged down in, how long is the wait time, and if it's more than, 2.5 hours, you're precluded, because that's just another way of adding to litigation. Is there some way to take the adversarial nature of this process out of the process? Got a lot of noise going on up there, I'm sorry. But
Yeah, we have a fire truck going by.
I think that there may be lots of ways to achieve that, and to me, that should be the goal. To make this process that works for injured workers, that makes doctors' reports seem credible to all parties, and to move these claims forward to the best of everybody's ability, and to return people to health. And I don't see any of these particular items doing that. This just maintains the status quo in terms of an adversarial relationship, and I don't think that's in anybody's best interest.
And I would like to make an observation. We think back to one of those earlier slides from a different meeting, which talked about 6 different doctors performing 65,000 exams. But when I look at the information here about the 2 different types of office, they're almost identical. I find that very astonishing.
Yeah.
Which slide are you looking at?
I didn't,
Let me see if I can find it. The high volume provider versus the,
Handout 2.
this would be handout number 2. This was surprising.
So what counts as a high volume provider for the purposes of this handout 2?
Those were the 102, 104 providers that performed, 72% of all
Okay.
IMEs in the study period.
And are there, my memory, and it's not at the top of my head right now, is that was really concentrated at the top. Like even of the 102, there was great concentration in maybe the top 10 or 15. Are the top 10 or 15, like what percentage of these are accounted for by those top 10 or 15?
We'd have to go back and look at it. That handout 2 represents the 104. How
Okay.
many of the survey respondents were seen by one of the 104?
Okay.
Yeah.
And just to go a little off that topic, I was very curious about the the video recording, you know, I'm really surprised to see that more people don't record their IMEs, because I remember when this first came about, you know, you have to bring in a big clunky VHS and have someone hold it on their shoulder while the, you know, exam was going on. A lot of people didn't do it. And, you know, my experience is whenever it did happen, it didn't go well. You know, it usually resulted in the IME calling the police or something, you know. But, you know, now with cell phones, you know, it's just so easy to do it, you know, and you know, I can envision people posting their IMEs on Facebook and YouTube and things like that. But I'm just surprised that you don't see more of it with the advent of the cell phone.
Is there a downside to it?
To video recording?
Yeah, I mean, I understand a claimant wouldn't want to get undressed and have it videoed. I mean,
Right,
that,
of course.
that much I understand. But if you could do it in a more discreet way or whatever, I mean, is there a downside outside of that? And this is not a loaded question in any way. I mean, this is, in all sincerity.
I don't know. It's just my observation is I'm surprised that more people don't do it. People tape everything now, not record everything now.
I mean, Matt, do you see an up or downside to it?
An up or downside to the recording?
To recording IMEs. It strikes me that,
Well,
you know, video doesn't lie.
I think a lot of what we're talking about, particularly today, is perception. And the perceptions of fairness. And I think, in a sense, there's an upside to a recording, just as, you know, police body cam footage is becoming more prevalent and more useful now. If it's, if there's a recording of exactly what took place, it seems to me that could give everyone more confidence in the outcome and in the veracity of reports. That's my answer. I'm surprised also that more people don't record, and I'm confused about what to conclude from that. Do I conclude from that it's because people have confidence in the integrity of the IME that they're going to see? I suspect there'd be some disagreement about that around this table.
Could be intimidated too.
Or is it because they're intimidated by that process?
I mean, part of it might have to do with the fact that you would either need a certain kind of technology or you need a third party present.
Mm-hmm.
Right? I mean,
Oh, sure.
Right.
That would be sort of, the phone's not going to be very useful for the, not selfie.
You're not going to do a selfie like
the whole time.
But they're you know, you can buy a tripod for $10 on
Yeah.
Amazon.
I mean, that could be something that's available. I mean, I was surprised by the numbers too, so kind of wanted to ask that question.
So does anyone want to go back and maybe address Mindy's point about our general directive, and when she was also saying that Joe had a good point about how do we make this a less adversarial process, and maybe it isn't by looking at, you know, necessarily these issues here in discussion, but taking a more broader approach?
I think there are ways to do it that would be unsatisfactory to everyone involved. Take the analogy to disability benefits. If you limit the duration of benefits of any type to 26 weeks, you see very few litigated disability benefits cases. But limiting benefits to an injured worker to 26 weeks, I don't think is going to be acceptable. You could legislatively limit the amount of total disability benefit, or limit the period of total disability benefits that anyone could have. But also not acceptable. There are plenty of people who remain totally disabled after a year or after 2 years. Bill mentioned, I'm not finished. Bill mentioned cross-examination earlier in our discussion. And I'm glad he did, because that's a significant check in this system to the mistrust or uneasiness that is involved in this adversarial system. I don't think that we're going to be able to all hold hands and sing Kumbaya at the end of the day and come up with a system that is not adversarial when you have the potential for lifetime benefits, and employers are looking at the potential for lifetime benefits, and there are claimants who should have lifetime benefits. That's that's a cauldron in which all of the facts and circumstances have to be stewed. So I don't think that we're going to end up with a non-adversarial approach to this, because frankly it's unsatisfactory to everyone involved.
Well, I have a suggestion. What if there was a way, and I'm not sure there is a way, but if there were a way to ensure that every treating physician was a gold star physician, the creme de la creme in his area, and everybody said if the claimant goes to this particular doctor, whatever that doctor says, we're gonna go with. And we knew that they had been vetted, that they were the same doctors that you yourself would want to treat with. Why is that? Wouldn't that somehow take a little bit of the adversarial aspect out of the relationship?
Mindy, at some point, aren't you going to say that doctor got it wrong?
I'm saying that
If that doctor
Not
does...
if Mindy gets to choose the doctors.
Come
on, let's be serious. Everybody can see where this is going from a mile away.
No, I don't think you can. I think that you're being disingenuous. If I told you that I would send the claimant to the finest physician, somebody from special surgery, to get whatever they need, would you tell me, no, I don't want that? Just answer that one question.
Mindy,
Would you say no?
Mindy, quite honestly, I read the board decisions, I read the arguments, the claims handling practices of the organization that you represent belie your claim of
Joe, why won't you
requesting
answer my
or
one
desiring to reduce the adversarial nature of the system, Mindy.
Question, Joe. If I said you could go to the chief of orthopedics at the hospital for special surgery, your claimant could go there and I'll accept whatever that doctor says, would you tell your client, no, don't go?
My client is the New York State AFL-CIO.
Would you tell
I do
an
not
injured
represent
worker-
individual
would you-
injured workers.
Would you advise an injured worker, no, don't do it?
I am
Would that be the
incompetent
result?
to represent injured workers. I've never represented an injured worker
I'm
before
asking
the
you,
workers'
would that
comp
be a
board,
ba-
Mindy.
would
I've
that
never
be a
provided
bad
legal
solu-
advice to an injured worker.
Joe, would that be a bad solution? If I said to an injured worker, I will send you to the chief of orthopedics at the hospital for special surgery to be treated and for whatever treatment you need, would you advise that that would be a bad thing to do?
Maybe Bill could answer that.
I was afraid you were going to ask.
Yes, sorry, you're the one who actually represents individuals.
I've actually been in situations like that before where, a carrier has said, look, you can get a second opinion, we'll pay for any second opinion you want. And we would suggest maybe special surgery or something like that. And, I have gone along with that in the past.
Okay, so that would be an acceptable idea.
Not all the time.
No, but in other words, but if it were possible, that would be something that might be of assistance to taking the adversarial nature of this relationship out of the mix.
If I had someone who had 3 failed back surgeries and couldn't walk, yeah, okay.
We're talking about a large
So
volume.
you're saying there's a chance.
We're looking at a very large volume of examinations, 65,000 done by 15 doctors. We over 150,000 in 2 or 3 years. So I don't believe the chief of orthopedics at any one hospital would be in a position to accommodate that volume. But to address the question of fairness, why not consider looking at the pool of individuals who are willing to perform an IME, and then have a lottery or a random assignment of an injured claimant to someone who is injured within the realm of that physician's specialty, so that the relationship between a referral source and the physician may be uncoupled, so that the doctor will any bias, which might be subtle or otherwise, can be eliminated by looking to create a pool of IME, and perhaps we do that by saying individuals that are agreed to be treating providers, or treating physicians, I'm not providers, sorry, strike that, treating physicians, would be in the pool for random selection and assignment based upon condition and geography.
I think that you would need to have some criteria beyond ready and willing as far as those IME providers. I'd be pretty uncomfortable with a random pool of anyone willing. If we were to ever go down a road like that, I think that the board, at very least, would have to be far more involved in making determinations of their, and they would need to be much more severely vetted.
Wait a minute, we already have a system that vets physicians, and not IME providers, vets physicians to participate in the Workers' Compensation Board, for which we have faith. So are you saying that you don't have faith in the system that is now out there to vet physicians to participate in the Workers' Compensation system?
I'm saying that I've spent 4 or 5 afternoons in this room listening to a lot of people say that they don't have faith in a lot of the people that are taking part in the system. I happen to not have been one of them who was saying it, but I've been hearing it over and over and over again. So I would think before I could go back to my members that I represent and say, hey, employers, you're going to get a randomized system, I'd want to make sure that the people doing those IMEs are capable of doing it fairly, capable of doing it properly. And I think that, I think there need to be a higher level of scrutiny than there is now.
So you would be in favor of perhaps the board putting together a module for the training and education of physicians who are willing to participate in the IME process, so that they can demonstrate their objectivity and their clinical acumen to accomplish that. No. And then once they have gone through such a training, then be part of that random selection.
I'd be willing.
I believe random selection is the key to impartiality and reduction of bias.
I'd be more than willing to bring that idea back to my membership. I'm certainly not willing to commit to it today.
I just want to point out, firstly, I don't think that's the answer, because, for instance, the New York City Law Department, our IMEs are random. We have several vendors, and who gets the particular IME is not up to us at all. It's on a random wheel, and then beyond that, who the IME vendor then hires to do the IME is way beyond our scope. So I don't think it's necessarily and I'm not talking about the quality of the IMEs, because I'm not sure that I'm always happy with them. So that's not the issue. I think that the place for the board to become involved is with the treating physician. Again, I believe if you put together a gold panel of treating physicians, I would be willing to return to what Joe said, to go along with whatever the doctor said. I would have to form it more clearly, but only in very exceptional circumstances would we want to challenge that.
Now, speaking on behalf of the Medical Society of the State of New York allows for free choice of an individual to choose their doctors, and we want to maintain that.
So then put together a panel, and you say there are X number, 1,000 doctors throughout the state. If you go to one of them, these are excellent doctors, you'll get excellent care, isn't that really the purpose of this? Isn't it to give
That is not the law in New York.
Like we're way beyond the scope
And
here. This is not a meeting about treating physicians.
And I also want to
This is a
point
meeting
out one
about
other thing.
IMEs and how to fix the problem with IMEs
IMEs
in
are
the
not a
system.
problem if you have treating doctors who reports are fair, legitimate, and reliable. IMEs are not a problem in a vacuum, and I think that to think otherwise is really foolhardy.
And when we
have to
started
get to
the
the-
conversation, one of the things that I indicated was that it seemed like a lot of the things that are listed in many ways directly relate to the provider access conversation that we had a few months ago. So
I think we really need to get to the bottom of the issue of independent physicians. And one of the big issues we keep dancing, it's Rick Weinstein. One of the issues we keep dancing around is that these doctors who are doing 5,000, 10,000 exams are not biased, and I'm guaranteeing you those are biased doctors. We don't have a way to review doctors and say, this guy's not really giving independent reports, he's a hired gun, this guy should not be allowed to do IME exams. And those people should not be allowed to do them. They're not independent reporters.
What
They're not,
about
and
the
we,
claimants' doctors who are referred by their attorneys? Are they independent?
they should be. We're
But they're
trained.
not.
Everyone's going to have some bias, and hopefully it's as minimal as possible. I, as a treating physician and a doctor who does IMEs, I look at it from both sides. And someone had brought this up before, which I think is absolutely essential for us to achieve our mission, is to require doctors to do IMEs to be treating physicians as well. If you're just a hired gun, you're going to say whatever you want, and you're not going to be unbiased.
You're saying when you do an IME, you're not unbiased?
I try to be as unbiased as possible, absolutely.
And just to the point about being treating and also doing IMEs, if you'll recall a few meetings back, maybe it was either the first or second, yeah. We actually touched on this in the report that you all received, and it was one of the slides. And of the count of IME providers, there's about 1,800 that do both, are treating and do IMEs, and that's about 86.5%. So we did discuss this, so in a way, that sort of gets to that question. But Bill, you had a comment?
Yeah, I had really two things I wanted to say. That in reference to what Mindy just said about the claimant's attorneys referring people to doctors, sometimes that's very necessary because we'll have someone with a serious injury who's only been to the emergency room or is seeing their primary care physician, and they have a serious problem. Look, I will very often say to them, look, you really need to see a good orthopedist or a good neurologist. Can you refer one? Well, here's a list, and I'll usually give them 3. And I'll say, find the one you're most comfortable with, find the one that's maybe closest to your home, but they're all reputable. The other thing too is about the IMEs, and again, this is just on my personal experience, it's anecdotal. When I get an IME for it, and I see the doctor's name, I know when I'm going to get a fair exam. There are certain IMEs out there who will give a very fair exam, and coincidentally, they're practitioners, they have patients of their own, or they've had a large practice and gone into retirement. This is what they're doing in retirement. But there are others where, I'll tell you, I can write the report myself. I can tell you exactly what they're going to say and what their conclusions are going to be. So there's a big disparity there. But, admittedly, there are some IMEs where I'll look at it and I'll say, you know what? This person's going to get a fair shake here.
All right, on that positive note, let's take a break. Unless you want to finish your thought.
Well, I just wanted to say that the same is true for treating physicians. As a defense lawyer, I can look at certain reports from certain treating physicians and say, this is a fair assessment of this person's condition, and I have those conversations with my clients.
Okay, let's
There's
break
another
to
positive note.
Another positive note. 1:45, we'll be back.
We're gonna get started?
We're getting ready.
All right, thank you. New York, are you waiting for anyone else, or can we go ahead and start? Are they gone?
Mindy's not back yet.
Mindy's not back yet, she was online, the ladies' room, I believe.
Okay. All right, well, why don't we go ahead and start? So the focus of today's meeting was to talk about the injured worker experience in going to the IMEs. And, the conversation has kind of drifted off of that. And the survey was done, and we recognize that maybe the questions weren't as artfully crafted as they could have been. But when you look at the totality of the results from the survey, it would seem that, for the most part, the experience that an individual has recognizing the adversarial relationship that exists in going to one is, for the most part, relatively positive. It's clean, it's timely, there's a certain degree of professionalism, wait time. Again, there's always going to be a variation, Some people may unfortunately wait 6 hours, but for the most part, the wait times were comparable to what any of us experience ourselves when going to our own physicians. So, given that scope within the specific topic, are there things that we should potentially move to the parking lot that we have already said we were going to revisit, having to do with IMEs and accessibility that are related to these, like location, or what things could we do or recommend statutorily, regulatorily, that would address those issues that exist within the results that we have from the survey. So again, I open it up for discussion because that is what we were trying to talk about today. Anyone? You want to say something? Go ahead.
You're talking about accessibility.
Yes.
Yeah, you know, I mean, we live in a very diverse state. You know, I mean, New York City is so different from up here or even further into Western New York. And, you know, and I know practitioners will sometimes travel hours to go to a hearing point, whereas we don't have that downstate. And, you know, I think public transportation issues come into play sometimes. A lot of our clients can't drive or they can't get a ride to the IME. But here, I understand upstate, it's not uncommon for someone to maybe drive an hour to go to an IME, whereas, you know, if you tell someone on Long Island they have to drive an hour to go to an IME, you'll be on the phone for 3 days trying to correct it. But I think there was a lot of variation throughout the state on that issue.
I mean, that's why I sort of would like to wait until we sort of see the breakdown of where those that were complaining that it was an unreasonable distance, where they're located. Because if we find, for instance, that 70% of those are in New York City, I'm not sure that we're going to see that that was a valid problem. If we see that 70% of them are in Utica, then it might lead us to a different discussion. But I wouldn't probably want to proceed much further until we knew what that breakdown looked like. And even then, that's a really small sample. But I think that it would at least give us some guidance as to what we, if anything, need to be focusing on in that area.
Yeah, I think for me, while I know a lot of work went into the survey, if we go back to prior conversations and some of the issues that have been identified and things that we know are out there in terms of the availability, the number of doctors, the quality of doctors in the system, I don't know if any of this survey result kind of changes any of that prior conversation or leads us down to a different path in terms of issues that we need to identify and explore.
Okay, anybody else?
Is there consensus on any issue that would potentially need to be fixed related to location or lab? You're looking to see the results. Is it fair to say that some of these questions or some of these issues that have been raised are probably location-based, so that really making a consensus on anything?
Well, I simply think that the question about reasonable distance is a geography question. I mean, we have to wait for sort of the breakdown. Everything else, I don't think has anything to do with geography necessarily. And I think by and large, I mean, most of these, as the states, it's relatively positive outcomes. So I don't see a lot of things that can be done.
Yeah, I think, the comment,
Go ahead.
New York being a big state, so, being part of a national carrier, when I think about the experiences in other states, it's not uncommon for injured workers to have to travel some distance. Again, it's just the geography of their states. So northern and western New York being similar to geographies in other states, that's not uncommon. So it's that one, the geography one, I think is going to be a challenge. And again, putting on a focus around downstate in concentrations. I don't know how that one is going to be kind of addressed such that the entire state feels the same.
May I raise something?
And I also know, talking to the availability. So even downstate, with the concentration of workers, injured workers, and those demanding IMEs, a lot of upstate doctors, and maybe some of the providers or any of the other ones, having upstate providers come down to meet the need, the demand for IMEs that does exist downstate. So that's one way that perhaps the availability upstate and the driving distance is one thing, but being able to address the demand and the availability of docs is being addressed by having those doctors be able to come down and work in a different geography.
It's now 2019. I want to remind everyone that they're physicians, they're not providers. And also, I think we should have to have a conversation about telemedicine. When we talk about the expanse of New York State, and I went fishing in the upper Delaware the last 2 days, I would drive 40 minutes without seeing a house. And I can imagine what it's like for an injured worker to need to find someone in the proper specialty to opine about an injury. So I believe we should at least think about or talk about telemedicine. Without entering my particular opinion or bias, does anybody else think it should be something that we should talk about, if only to dismiss?
How would you apply telemedicine to independent medical examinations, doctor?
I don't see how one can, but I believe we should talk about telemedicine so that at least someone thinking about it might say, oh, has anyone considered it? And I would like to say we have considered it.
So there are actually other states that do use telemedicine for IMEs. It's sort of an emerging trend, or maybe not a trend yet. It's starting to occur in other states. And what may be done is the individual would go to the office of a physical therapist. And the physical therapist could help with the range of motion, but it would be done through Skype or FaceTime or probably a HIPAA secure type of video.
I can see Bill smiling as he conjures his cross-examination questions.
That's exactly what I was thinking.
About whether the IME has actually met this person and personally been present for the examination. Unless there's some advanced software available to assist with measuring range of motion or sensory deficits or muscle weakness, I'm not sure how that works.
You could have a hologram.
But it may be just because I lack imagination.
Are there certain types of exams that you would consider? Like
Eye color?
Surgery, or not range of motion? Like,
Well, it's possible that certain psychiatric or psychological conditions could be assessed over a video link. But still, those assessments rely a lot, I think, on visual cues and body language and whether the patient is perspiring, things that you might not be able to see over a video link. But I'm well out of my element when I start talking about psychiatric examinations.
Yeah, and I mean, it's really a group discussion, like whether or not, I'm just saying there are options to kind of split it out if people want to consider telemedicine. If you don't want to consider it, that's okay too. It's up to you guys to talk about it. But I know generally we talk about IME exams, it's like a bucket of everything, but there are like different things that have different nuances. So I guess the question is this something that you would want to separate the different types of IME?
Like Stephanie said, the IABC had I don't know if at their conference recently they discussed it, but there was an article in their Perspectives magazine that talks about telemedicine, and they talk about the emergence of it in workers' comp, that there are at least 2 states that are using it. So if it's something, if anyone's interested in the article, you know, you can look it up, or we can send it around. For better or worse, it would, you know, give you something to read, to ponder, and figure out if we wanted to discuss this more seriously, or research it more seriously.
Please send it. I thought it's interesting that you made mention that we heard a comment about physical therapists doing range of motion, minimal muscle tests and the like. And when one thinks about the state education description of the title physical therapist, it says someone who can perform tests and measurements to aid in the making of a diagnosis. So even in that statement within the state education law, it is not to make a diagnosis, but to aid in, which also then, to me, means there's a limitation even as far as that goes. But I'm very interested to see what the article says.
Yeah, I would like to see that article.
You know, in my experience, it's we will get calls from time to time from claimants who say, you know, I don't know if this IME company realizes that I live in Suffolk County and the exam is in Queens or it's in Nassau County. And, you know, the way we'll remedy that is we'll call the carrier up and we'll say, listen, can you provide someone closer to the claimant's residence? And normally they'll do it. Sometimes if there are time constraints or if it's, especially if it's a doctor, you think you're going to get a fair evaluation from this, they'll just go to the exam. You know, just go the extra 15, 20 miles to do it. But, you know, as a practical matter, it does come up from time to time, and usually we'll get some accommodation on that. You know, but I think that, you know, most people are showing up for their exams. And, you know, I think downstate, especially in New York City, the big consideration is it accessible by public transportation? And public transportation is not so good on Long Island. It really isn't. So, you know, are they able to drive there, or can they get someone to drive there? Or will they provide transportation?
What do you find when you ask carriers to provide transportation?
It depends. It depends on how serious the situation is. If you have someone who's just not mobile, or they can't be weight bearing on a certain extremity, they will accommodate. And sometimes they won't.
So we've been surveying all the IME entities, and that was one question that we asked, is about transportation, interpreter services, and videographers. And I believe they all said, all of the folks that responded, which is about 2/3 of all IME entities, indicated that they will arrange transportation. And typically it's the carrier that has a contract with one or more transportation vendors. So they all say they do it, but maybe there's parameters that you have to meet in order for them to okay that.
And again, sometimes it's just really an issue of the IME service not being familiar with the geography. You know, oh, it's Long Island. That's easy. Well, Long Island stretches about 150 miles.
White Plains, Rochester, anything to add? Okay, it seems like we want to see some more information on where some of these situations that were not favorable occurred before we move forward with any consensus. To the extent we have consensus on anything on this category, it would probably be to take a further look at telemedicine, just to see how and if it fits into the overall recommendations this group is going to make.
I wouldn't say.
No? Okay. Go ahead.
That's it.
Okay.
There's no consensus on it.
No consensus on telemedicine?
No.
Okay. No, I just that we would get more information and just see. It could be that no one wants it.
Well, I mean, the board's free to get more information. but
Okay.
I don't concede.
Got it. All right, so why don't we move forward to what we'll be talking about next month, which is the cost of the IME.
Can we go back to wait times? I think having somebody wait 6 hours in it is inexcusable, and I believe there should be a cutoff for somebody who appears in a timely fashion for an IME, at which point they can consider it an exam which did not go forward in order to protect the claimant from sitting in their car with the phone at their side. They might have children at home, meals to prepare, or any other obligation that individual wants in the world, and that's not acceptable. I think we should do something about that.
Isn't there already a cutoff of sorts in the
As far as
sense that
scheduling, it needs to be in business
it
hours.
needs to be within normal
8 to
business
6,
hours?
Monday through Friday, but there could be a waiver if you want to go outside of that.
But 9 PM is certainly past normal
Oh, yeah,
business hours.
yeah.
So within the regulatory construct that you guys work on, there's time measures in terms of when IMEs have to be open?
But when they have to be scheduled?
When they have to be scheduled.
During normal business hours.
Okay, but there can be a waiver, so that, I'm just trying to, like, if we were to try to fix something in these egregious circumstances, it would be regulatory? I don't know. I'm
Well,
asking.
if they want to arrange an IME in the only convenient time for the, let's say it must be performed in the claimant's home because of an extremely severe condition, and they can only do it on a Sunday,
Right.
they can agree to that.
Okay.
But accepting that
I
very
know.
unusual situation,
Right.
it's going to have to be a normal business.
I mean, you could do a shifting from scheduled for normal, sorry, Joe, I didn't mean to cut you off there, but scheduled for normal business hours versus performed during normal business hours. It's not necessarily addressing the wait time, but it's guaranteeing that you're never going to have a claimant sitting in a car till 9 o'clock at night, which is, I agree with Bob completely, is absurd. I'm a little bit nervous about, what we would do, what construct we would create, and how much more litigation that could cause if we say 3-hour wait, or whatever it is. But I mean, I think that there may be some reasonable, if it were to modify that from scheduled to performed during during business hours,
Okay.
I think that we're at least not creating hazardous situations like the one that you had a client in.
Yeah, and that's an extreme example.
Yeah, of
I don't hear
course,
that too
yeah,
often.
of course it is.
I don't want to complicate this anymore, but, there's also a concern about claimants who are working full-time, they're back to work, and an IME has to be performed, and they have trouble getting the time off to go to the IME.
That their employer is requesting?
Could have a different employer.
Yeah,
Could be.
that's, yeah. We could schedule that one at 9 o'clock at night, I guess, but,
So should they be allowed on Saturdays?
well,
They are allowed on
yeah.
Saturday by consent.
But that is a concern that some of my clients will have. How can I take off in the middle of the week? My boss is gonna crazy if I do that again. I've already been out for 6 months.
Particularly if they've recently started a new job.
Exactly, yeah.
So in a case like that, is there anything preventing, a carrier or an employer from unreasonably withholding consent? Or no?
Unreasonably
Withholding consent.
To do something
Outside
normal
yeah,
business
so,
hours?
I mean, like, there's a really contentious case, and they just want to jam each other back and forth, and, they know that this injured worker has a new job, and they're going to be as difficult as possible. Is there any provision of law that would, prevent them from doing that?
I think what prevents them from doing that is a workers' compensation law judge. Because typically if somebody didn't come to 3 IME examinations, there would be a request to suspend benefits for failure to go to 3 IME examinations, and the claimant would get an opportunity to explain the circumstances. And in my experience, judges will say, well, go to the next one. Or the judge may turn to me and say, Mr. Mead, this person needs some accommodation. Intervene with your client to get some accommodation. So I don't.
The definition of a failure to attend is a litigable issue for the
but there's no, no protection, right, until after, you know, they've missed 3, they've had their benefits suspended.
Nope.
No,
The
no,
carrier
no.
would have to make the application, and it would have to say that, you know, this person was scheduled at the following 3 times, failed to appear at each 3 times. Here's my application to suspend benefits, and then,
The application would be litigated.
yes.
They
The
wouldn't cut off
application could,
benefits.
Not an automatic.
those applications would rarely be litigated. I mean, in my experience, they wouldn't normally be litigated unless the claimant was willfully refusing to attend an independent medical examination.
And there's a special little provision in the variance rules if the injured worker fails to appear at a scheduled IME for a variance, because it's one and done there and they can deny. So the injured worker could say, I had a reason for not attending that one exam, but the variance should not be denied.
Any more discussion on that?
No, but before we move on to
Yes.
what's coming next, I do want to, you know, reassert my request, or first inquire. Has the board received any information about written claims handling practices dealing with the use of IMEs?
Written claims handling processes, no, I don't understand. Like,
So
the-
previous,
say what?
2 meetings ago, we had a conversation about whether or not
I
employers or
remember.
carriers have written claims handling processes that deal with, you know, their request for an IME, how to handle the IME process. And there was some back and forth, and I said that we put it, or Michelle said we put it in the parking lot, and I promised to revisit it every meeting because I think that it's pertinent. If there are written claims handling practices out there that address how and when a company decides to choose or decides to request an IME, I think that that's pertinent. What they do with the results, whether or not you know, a report of X or Y variety triggers some other action, I think that those are all pertinent.
Excuse
We
me.
haven't received anything like
Yeah,
that.
we don't have any
No.
claims handling IMEs from carriers.
Did someone want to?
Mindy, did you have something?
I was just asking, was a request formally made to carriers?
No, just.
I think it was a
in this meeting.
conversation, it was a conversation regarding lists. And do these lists exist in terms of, like,
Well, so the list question was a different conversation, but I'm happy to reassert that. If there are any, you know, lists of doctors who have been, you know, a do not use list, blackballed, based on whatever, I'd be interested to know that as well. But no, my understanding is that there was no formal request, it's just that I've requested it, I've requested the board to request it, and we still don't have any. I think that it's pertinent for the task that this group has taken on.
I think the
Excuse me,
discussion
I-
at the meeting was really to, how does that add to the discussion about IMEs? And whether or not people view those policies and procedures as a business tool.
A proprietary.
And I think the discussion, at least what I recall hearing from some of the carriers, was we wouldn't release it.
Yeah,
The conversation each time usually ended that way and also ended with the fact that some of this may very well be privileged information, so.
I don't contest that it may be privileged information.
I know you didn't. We're just, we're
I would
restating what you
imagine-
stated.
I would imagine
Yes.
that you wouldn't contest that they're free to waive privilege.
I believe
And
that
just
is
for
the
full
case.
disclosure,
yes.
Joe, we've had some off-the-record conversations, and the answer is we would not release it, we consider it proprietary.
You would, so, you would not release it, do you have it?
And no, the people we approached,
Oh, okay,
their answer was, we will never release that information.
okay.
So I don't know that we want to,
We can't
you know.
compel.
I'm not
compel
suggesting we can. You know,
So
this is,
I think that we heard the ask, and we've done some unofficial inquiries, and we get kind of the same answer.
well, I appreciate that. I think it's a valid piece of information, and I think that we should note it in whatever report comes from this group, that there's valid information out there that at least some players in the system refuse to provide.
Joe, I would have I would actually take exception to that. I don't know that this is how people run their internal systems. I'm not sure that's really very relevant to this inquiry. And I would actually say that that is certainly outside the scope. If the law was changed, if the system was different, they would run their systems differently. I don't see that, I don't see that as a particularly relevant inquiry. I think it's invasive.
Correct me if I'm wrong, but I think the last time that we had this conversation, you represented that your client doesn't have such, written claims handling practices?
Actually, that's true, and I believe that I was accurate. I'm just saying I don't see that as a necessary part of this inquiry. So that to say that that it is, and state that as a fact, I think is incorrect. That's all. And in any event, it seems to be moved.
A few meetings ago, Clarissa mentioned, the usefulness of having some of the IME providers, some of the IME companies present, and I believe that Matt sent around some names, if I'm not mistaken, if I'm remembering correctly. Are we anywhere near inviting and setting a date and time for any of that for a future meeting?
Yeah, that's the
June meeting.
Oh, that is the June meeting. Oh, okay, I'm sorry.
So we've
How did I miss
surveyed them recently, the responses were due last week. I've heard back from about 50 companies, asked about their process for scheduling, so we'll have, the way it's done today, and then we can also make available one or more IME entities
Sure.
to be here to be able to answer your questions.
And I apologize because I just learned that I was not here yet when that was mentioned earlier. Tardy guys.
But just so people know that, so we do expect to bring a few of these companies in to be available to answer questions or, answer whatever, issues may come up. So that meeting may run a little longer, so just want people to be prepared because, usually these are pretty full agendas during the regular window we have, but adding these folks and giving them an opportunity to respond may just push us beyond our normal 3-hour mark.
And I don't know if we've discussed what if we have any parameters as far as the volume that some of these IME providers may be engaging in. Do we want someone on the high, volume, someone on the low, or just folks in the middle? Do we have any thoughts about who we actually want to hear from?
We're talking about the doctors or the vendors?
Because when we're talking about entities, right? Yeah.
I think that we should probably hear from a vendor that does a significant amount of business, and if possible, perhaps some geographic diversity. I don't know if that exists, but I think that may be pertinent.
If we had 2 or 3 vendors that have a cross-section, large, small, upstate, downstate, we can find that cross-section, and that would be beneficial for the conversation.
Just make the list perfect.
We always do.
Okay, so the idea is to have them talk at the end of the meeting in June, right?
Right, because we already have a topic for June, which we can talk about.
And is the format expected to be them making a presentation or submitting to a grilling?
Well,
Congressional hearing.
I guess that's open for discussion. I think you guys had asked some questions about the process itself. And we thought we'd do a little bit of research and give you kind of a summary of the process that we've been, able to discern from what was submitted to us. And then we thought we'd leave them open for questions. I mean, if we want boundaries, we could talk about, what we can ask them, but we just thought that you guys wanted them available to answer whatever questions might come up. And they seem to be, willing
right.
to participate, so.
Do we maybe want to submit questions ahead of time, and then if we have follow-ups, we ask them rather than sort of an absolute open form? I don't care either way.
They'd certainly prefer to have some sense of what might be asked.
I think it just might be a little more orderly that way, but it doesn't limit us with the opportunity to ask a follow-up if need be. I don't know if that's an idea.
Yeah, I think certainly asking about the nature of the relationship with their client compensation type models, I think that'd be inappropriate for a forum such as this. Best practices, also, I think, probably not a question to be asked as well.
So templates that are supplied, if any, information such as that, no-show, late fees, things like that.
So are these things that are appropriate or aren't appropriate?
These are appropriate questions.
I think there were
No,
two
I said
different
are
things there.
I think first started with
Yeah, so,
inappropriate.
okay. So one is saying are not, one is saying are. I'm not, this isn't like a judicial forum, right? These people aren't gonna be under oath. There's no way for anyone here to compel them to answer a question that they don't wanna answer, but I'm not gonna agree not to ask about certain topics. I mean, compensation structure, how they assign these cases, to me, that's the primary pertinent information that these folks can provide.
I think the expectation was that it would be about the process and how they're scheduled and things like that. So I think that was certainly within the expected discussion.
Perspectives on the market, right? Supply of providers, timelines, time frames, challenges that they're seeing, because the volume that essentially runs through them, there's perspective there.
So do you want to give them an opportunity to do a 10-minute presentation before we do questions? That they can give us some feedback on those general categories?
I think it would be interesting to hear what they see as the problems with the system,
So the challenge in the system.
from their perspective.
Some of them might be watching.
Well, that's exactly right.
Yeah, that's fine.
Some of them are watching.
Yeah.
Okay, so we'll give them, 5 to 10 minutes to talk to us about what they see in the system, what are some of the challenges that they're facing as an IME entity. And then we can ask them questions, and like I said, they can answer or not answer depending on how comfortable they feel.
I would expect them to resist telling you how much they charge, but not necessarily that they're paid a flat rate regardless of the outcome, or whether they're paid more for a carrier-oriented opinion.
I'm gonna go in with very low expectations and be happy with whatever I get.
Fair enough.
Okay, so does that work for people?
Do you want people to send questions to you as well, or to the mailbox? Focus group?
They're certainly welcome to. I think we've kind of taken some
Okay.
notes on what topics they would like to discuss. We'll provide that information as general areas that may come up. We'll ask them to do a 10-minute presentation on their role in the challenges in the current IME system, and then we'll open it up for questions.
Sounds good.
Is the mailbox open for anybody to submit questions?
Yeah.
Mhm. So anybody watching who has questions for these folks, they can submit them through the
There's a
mailbox.
link on our website where these videos are housed and where all the handouts and whatnot are. It's IME comments at wcb.ny.gov.
Thank you.
All right, so our next meeting is June 13th at noon here in various locations. And if you have comments or questions you want to send before, please do. But I anticipate a lot of people being here for the session. So thank you again
Thank you.
for the day, participation. I will see you in a month.